somewhat like coming into a movie right toward the end, because as was pointed out, if you define the problem as corporations and labor unions speaking out about elections and expressing their views on who they think should be elected or not elected, it wasn't until the 1940s, when the Taft-Hartley Act was adopted, that actually the speech of corporations and labor unions were prohibited. It was contributions in 1907 of corporations, and before that, nothing. And I take I guess, a broader view of this, and because I would start not in the 1940s and simply picking out one group or another group that some people may not like or want to hear from, and whenever politicians and their allies whenever they don't want to hear from a group, they cannot help themselves, they immediately run to draw up a law to shut them up. And of course that is what Congress did in a bipartisan way, shutting up principal advocates for each side, corporations and labor unions, in the Taft-Hartley Act. I think it really goes back many centuries, because until the founding of our country, the problem, as I would define it, was that the government had the power and used the power of law to prevent people, citizens, from talking about the government, and particularly criticizing the government. Before separation of church and state, if you criticized the government, you would be arrested, you would be tortured, many of you would be murdered, and you'd go to hell. Now, after separation of church and state, you were just arrested, murdered, and tortured. So I guess that's a slight improvement, but was the nature of things. That was the relationship between the government and the citizens. And it was the founding of our country for the first time in the history of the world where our laws and our Constitution was placed on the side of the citizen in this dispute between citizens and government, and what role citizens can play in the government, and particularly what they can say about the government. Because the First Amendment protects the four indispensable democratic freedoms about which our democracy and our experiment in self-government would be impossible. So that's the reason they placed them in the First Amendment, and that's the reason that amendment was first, and that was the purpose. And it was, as was suggested, intended to be a mandate or a prohibition. Congress shall make no law abridging the freedom of speech and press and assembly and the right to petition your government. But the problem has been, one of the problems have been, is of course this runs directly counter to the interests of incumbent politicians in the government, who have always wanted to have power to suppress those that would criticize them. And at the same time, occasionally the Supreme Court has had the same problem with the word no that my daughters did when they were growing up. I mean, they thought no meant, well, it's okay this time, Dad. And so, that was, that was really the beginning of our experiment on the relationship of the citizen with the government, and that is that the laws were not to be used by incumbent politicians to shut up those people that they don't like. Well, of course, politicians being who they are, human nature being what it is, and the views of those in government being what they inevitably are, which is that criticism is harmful against our interests, and we're going to use the law because we can to do something about it. It wasn't very long before, as mentioned, the Federalists, trying to stave off the emerging Republican Party of Thomas Jefferson, passed the Alien and Sedition Act, and people were prosecuted and went to jail for criticizing the government. Of course, that failed. Jefferson was elected. Not only was the act repealed, but those who were prosecuted were pardoned by Thomas Jefferson, and those, for their crimes that they were convicted of there. Of course, from that you fast forward, as was mentioned, to the now Tillman Act, the notorious Democrat congressman, segregationist, who was concerned about corporations supporting his or her opponent in office, in his election, and who, as incumbents will do, use the law to against their enemies to suppress them, and that was the Tillman Act, which said that corporations could not contribute. It wasn't then until the 40s where that was applied both to labor unions and to independent expenditures. That is, people not contributing to a candidate, but simply speaking out themselves about their positions on elections. Now, one of the big questions from the 1940s through the next several decades was, does this include issue advocacy? In other words, does this prohibition on making speeches in connection with an election mean that you can't, like say in an ad, well, Congressman X supports Y. We think Y is a really bad idea. Would you call up your congressman and tell him to vote to change his mind and vote against Y? That is talking about issues that are involved in our governance, and of course issues are the critical mechanism by which you and I talk about the government, share ideas, understand what the government is doing to us and for us, and it's one of the principal ways we involve ourselves in the government. Well, for much of that time, the reformers wanted to and the politicians, not only wanted to stop people and groups from talking about who they think should be elected, but wanted to shut them up from talking about issues, talking about what the government's doing, what is the position of particular public officials, what are they voting for, what are they voting against. Wanted to shut up basically the entire currency of speech related to the government that citizens could participate in. Well, fortunately, this is one of the principal areas where the Supreme Court, in the cases he was just about ready to speak about, which is Buckley versus Vallejo and Mass Citizens in 1970 and in 1976 and 1986, protected. That is, they recognized a distinction between saying vote for or vote against a candidate and talking about issues, what the government's doing, what politicians and governmental officials are doing in office, what they're supporting, what they're opposing, and criticizing them for that. Now, of course, this distinction made politicians unhappy. Politicians don't want people to be criticizing them, don't want people to be talking about them, don't want you to know what they are doing if they don't want to tell you. So that was the genesis of McCain-Fine laws. One of its provisions addressed what is called electioneering communications. That is, if you just do a broadcast ad within the proximity of election and all you do is mention a candidate, that would be a federal crime. So if you ran an ad like that, paid for by corporate or union funds, you would go to jail. Now, the premise of that prohibition was another case called the Austin case. This is Austin versus Michigan Chamber of Commerce. And this is where, for the first time, the U.S. Supreme Court permitted a discrimination among speakers. In other words, saying certain speakers can be prohibited from speaking, and that is, they upheld this Taft-Hartley provision that said that corporations could be prohibited from speaking about elections. And they upheld that as the first time that that had been done, on the basis that they argued that the mere participation of a corporation in our election, and by extension labor unions, would corrupt the election. Well, and of course the Supreme Court in 2003, when they upheld this electionary communication broadcast blackout period, relied upon that decision of Austin that permitted a discrimination among speakers and on the basis that their participation was conceived by the court to be evil if it would participate in our elections. Those are the two things: the Austin decision about evil participation of corporations in our unions, in our elections, and the McConnell upholding of McCain-Feingold's broadcast ad blackout period that became the centerpiece of Citizens United. And Citizens United involved a group, an advocacy group of not-for-profit, that wanted to do a movie called Hillary the Movie. And it was about her conduct as a U.S. Senator, about her conduct in the White House, and expressed strong views opposed to her election. Of course, the problem was for Citizens United is she was running for election for president. And these rolling blackout periods were starting more than a year before the election, as you had primaries. And of course, that meant that their movie was largely prohibited throughout the United States. Or if they ran it, you would go to jail. Well, this came up to the U.S. Supreme Court on the question of whether or not Hillary the Movie could be banned. Now, an interesting thing happened in the oral argument, which I think led inexorably to the decision of Citizens United overturning the corporate ban, and that was this. It was a question to the representative of the government and the Federal Election Commission. And that question was, does the FEC think, the Federal Election Commission think, that they have the authority to ban a 600-page book if there was one sentence in the book that urged people to vote for or against a particular candidate? And the representative of the government said yes. Now, those of us who are involved with the Federal Election Commission and the laws have known that for decades that has been the position of the Federal Election Commission. But you should have been in the courtroom that day. The silence, the stunned silence. You know, that this deep, dark secret that we are actually in the book banning business at the federal level and the Federal Election Commission. It was stunning. And the Supreme Court then ordered very unusual re-argument on the question of going to the central issues of whether or not the government has the power to ban books, ban movies like Hillary the Movie, and the court said they don't, and reversed the Austin decision, struck down the electionary communication blackout period. Now, my view, and the decision, and I won't talk about my view till we get to questions, but the decision was based on one fundamental notion. If you read the First Amendment, it says, Congress shall make no law. See, that's written differently than a lot of the amendments that protects the rights of people. Like the 14th Amendment talks about people not being deprived of due process of law or equal protection of the law. Others talk about citizens not being deprived of certain rights. This is not written that way. This is written to protect speech. So anyone, illegal alien, anyone you might say, that can speak and is subject to our laws, anyone. That speech is protected without regard to who they are, who the speaker is. And that's what the court in Citizens United reaffirmed. They said, look, the First Amendment was written to prevent to protect speech. It doesn't countenance discrimination among speakers. And therefore, a law that would punish people based upon who the speaker is unconstitutional.
Bopp, a good point. Robert?
So the Citizens United case does involve these grand principles. I'm not going to start from the origin of the country. I'm going to do it the other way. I'm going to talk about the case and work back, and you'll see my view on the underlying principles. And I think we can see a different point of view than Bopp just put forward. I think that Citizens United is a case that defies common sense. It defies generally held understandings of how the world works. And I think it's a suspension of disbelief case. And one of the problems with talking about it only in esoteric principles without acknowledgement of real-world applications is you lose sight of some common sense. So I want to try to infuse that. There are legal. I want to do two things. I want to talk about the legal principles that are involved, but also the way this has played out in the 2 years since the decision was issued and what it means for us going forward. And it's why I think that the decision was wrongly decided, but also a serious and deep threat to the functioning of our democracy, and it has to be undone. There are at least, I think, 3 components of the decision itself. Let's step back for a second. What the decision held, just to be clear, because we're going to parse it out. The decision held that corporations have the right to spend whatever they want to influence election outcomes. So with the caveat that they can't make contributions directly to candidates. So actually the laws, the regulations that were affected were fairly narrow, but the holding was very broad. So corporations can spend whatever they want. For-profit corporations, Exxon, DuPont, General Electric, spend whatever they want to influence election outcomes. That's quite dramatic. There are a couple of premises before I get into the details of that. One is that spending, Mr. Bopp talks about speech. An underlying premise is that spending on elections is a form of speech that is the same as people talking. And the other has to get to whether the rights of people are the rights of corporations, and I'll get to that in a second. The framework for the way the court has looked at restrictions on campaign spending is to recognize, well, there is, even though it's held that spending is a form of speech, that there are countervailing interests in making sure that elections are honest and that aren't corrupt. So one thing the court held in Citizens United was that so long as contributions aren't made directly to candidates, there's no possibility of a corrupting influence. So if the money is spent by a corporation directly or given to an intermediary organization that spends the money and doesn't give it directly to the candidate, it doesn't coordinate its activity with the candidate, by definition, there can't be any corrupting influence, and by definition, no one could think that there was a corrupting influence. You couldn't even imagine, you couldn't reasonably imagine that there was any corrupting influence because there was no coordination. Now, I don't think there's anybody in the United States, aside from the 5 members of the court, who believes that to be true. I just don't believe anybody believes that to be true. A casino magnate just gave Newt Gingrich $5 million to spend, an affiliated organization with Newt Gingrich to spend $5 million in South Carolina attacking Mitt Romney. It is implausible to think that there are no special favors that come as a result of that. Now the guy, maybe he's a total believer, he's a longtime friend of Newt, so maybe he doesn't intend to capitalize on it. But it's implausible to think that there's no corrupting influence. And in fact, the court has recognized in the past that there is the appearance of corruption in the context of those kind of expenditures on behalf of judicial candidates. That's the first thing I think is just utterly implausible. The second thing I think is utterly implausible goes to the Austin decision that Mr. Bopp was referencing. So Austin was, I think correctly characterized, with some editorial comments, but correctly characterized, that there was a notion in Austin that was different than this idea of corruption, because corruption is basically, as the court looks at it, as it was defined even more narrowly in Citizens United, is very kind of like, basically bribery, right? You give something, you expect to get something back. Austin said there was a different thing going on that's a real concern to the public, besides actually a quid pro quo bribery. I give you the donation and I expect you to give me some government benefit back. And this was the idea of distortion. So what they were saying was, in Austin was, corporate spending on elections basically tilts the field in a way that's fundamentally unfair. Now, I also think that happens to describe the way basically everybody looks, not everybody, I'm exaggerating, the vast majority of people look at what goes on in Washington and state capitals. The massive corporate spending election unfairly tilts the field, tilts the elections, and it tilts all the issues that Mr. Bopp correctly says we should care about. There's poll data that shows people view this to be the case, and I think it's pretty much common sense. Okay, but in Citizens United, that notion was wiped away as a legitimate governmental interest. So the court said that there's no legitimate reason, be that as it may, no legitimate interest in restricting corporate spending to try to stop this distorting effect. And I think that's arguably the most serious damage that was done by the decision, because that is exactly the problem with our politics today. The third thing that the court did is the one that I think surprises people the most, to the point of utter astonishment, which was it did not make a distinction between real, live, breathing human beings, people like you and I, as Mr. Bopp said, you and I, citizens, people, did not make a distinction between people and for-profit corporations. Now, people do work in corporations. The corporations have executives who are people, they've got workers who are people, but the corporate entity is not people. The corporate entity is a legal structure, and it has all kinds of special advantages. It is created by the government. It's not created by birth. It is created by the government. The government gives it a charter, the right to exist. We give it, the government, we the people, through our government, give corporations special powers, limited liability, so there's restrictions on the ability of shareholders to be held accountable for what corporations do. Perpetual life, other things I'll talk about in a second. This is a distinction of significant consequence, and it was completely ignored in the Citizens United decision. Justice Stevens wrote a very compelling dissent in Citizens United, and he said this: so the fact that corporations are different from human beings might seem to need no elaboration, except that the majority opinion almost completely elides it. And then he went on to explain some of the differences, and there are more. But he said, it could be added, corporations have no consciences, no beliefs, no feelings, no thoughts, no desires. Corporations help structure and facilitate the activities of human beings, to be sure, and their personhood, in quotes, this idea that they should be treated as people under the law sometimes, often serves as a useful legal fiction, but they are not themselves members of we the people, by whom and for whom our Constitution was established. He could have said some other things. He could have said corporations don't breathe, so they actually don't have an interest in the quality of our air. They don't drink. It doesn't matter to them if the water is polluted. They don't eat. They don't have to worry about whether or not our food is poisoned. They are motivated by they're designed to do a single thing, which is accumulate profit. This works very well often for many. We get all kinds of great goods and services from corporations, but their purpose is to make profit. If you let them come into the electoral process, given that they get special advantages designed to accumulate wealth, and you know that they don't care about the well-being of the community or the future of the country or posterity or their cousins or their kids or their neighbors or who they love. All they care is about making profit. And you gave them, going in, the ability to accumulate profit and have massive wealth, and then you ask them to pay into the system to determine the outcomes of elections that will influence the policies that govern we the people. You did something awfully foolish. And you've also set up the stage for our democracy to be deeply, deeply undermined, as it has now been. What's the evidence? Well, we don't have too many elections to look at, but we've got enough evidence to know that things are really bad. And I should say, they were really bad before Citizens United. And some of the things I'm about to describe, Mr. Bopp might fairly say, are not just Citizens United. It's sort of a set of recent decisions and some FEC actions, but they're kind of encapsulated by Citizens United. They've been enabled by Citizens United, facilitated by Citizens United in a variety of ways. So we only had, the only election experience we have is 2010 at the federal level, 2011 in the states. and the early primaries now in 2012. In 2010, $300 million went into independent organizations, reported, much more for sure. $300 million went in reported to independent organizations to influence election outcomes. That was more than the 20 years previous of midterm elections. About half that money went into organizational structures that weren't required to report who their donors are. So we actually don't know who put the money in. From the ones that are reported, we do know it's a very small number of super wealthy individuals and corporations that have put the money in. So you have this massive infusion of money from a very small number of people. And about half the money, sources of half the money, not even disclosed at all. Huge impact for $300 million. Actually, turns out you can buy stuff for $300 million. In 75 of the 75 races where power changed hand in the 2010 federal elections, the outside groups supported the winners in 60 of them. And we've seen all kinds of other impacts. In the Oklahoma City council race, a position that pays $10,000 a year, so this is kind of a sideline job, $600,000 went in against the guy running for city council from oil interests. This is just no way to run a democracy. All this infusion of money and the possibility of infusion of money has a chilling impact on who runs and on what people who get elected can do. So consider the case of a guy named Peter DeFazio, who's a representative, U.S. representative congressman from Oregon. He operates out of a relatively safe seat. He supports the idea of a tax on Wall Street speculation. Each time a share is traded or derivative is traded, there should be some small tax on it. Wall Street doesn't like this idea. Two individuals funneled $600,000 into the race against him because they think this is a bad idea. Now, DeFazio is in a pretty safe seat. He was able to win anyway. But $600,000 is a lot of money in a congressional race. You go for about $2 million a pop. So I can tell you that DeFazio himself is very aware of what happened and acutely sensitive to it, but also the rest of Congress. Anybody who's elected now knows. You support this idea, but also other ideas that may offend super deep pockets or corporate interests. You're putting your position at risk. And it's nothing to do with sort of the will of the voters. It's just the money that's going to come in. Of course, the will of the voters ultimately decides, but the money has a huge influence over what happens. Last, without sort of going on too long about this, we've already seen the impact in the 2012 election, and it's going to be orders of magnitude worse than anything we've already seen. So, as I referenced before, in Iowa, I actually referenced the South Carolina story, but in Iowa, a super PAC, one of these independent groups affiliated with Mitt Romney, spent several $1 million attacking Newt Gingrich and basically destroyed Gingrich's candidacy in Iowa. Now what they did is they ran a barrage of negative attack ads against Gingrich, and they worked. Now, people run negative ads because they work. Everybody hates negative ads, but they work. There's a limitation when candidates want to run negative ads, so because they may be tarnished by running things that turn people off. But Mitt Romney disclaimed any responsibility for the ads because he wasn't coordinating with his super PAC, Restore Our Future. Restore Our Future is an entity set up solely for the purpose of helping Mitt Romney. Has no accountability to anyone. No one knows what it is. Doesn't care about its reputation. So they were able freely to run these vicious attack ads. Now, Newt's returning the favor in South Carolina. Now, there's a huge role for candidates criticizing each other and drawing distinctions, and it may well be that most of the things these guys were airing were true, but that's not the point. The point is you have this outside infusion of money with these negative ads that turn people off, and where the outside forces are actually controlling the campaigns. We saw it in the 2010 elections, the money that came in, that $300 million, looking state by state, about 5-1, 7-1, 6-1, depending on the state, spent on negative advertising versus affirmative advertising for candidates. And as we look forward to the 2012 elections, the Koch brothers have announced they intend to spend $200 million on the election. Karl Rove has announced he intends to raise $240 million through his two independent organizations to influence the election. The U.S. Chamber of Commerce will not be outspent, I guarantee you, by either of those two entities. So just between the three, we're starting to approach $1 billion of money to affect the outcome of the election, not from the candidates. And it's not just on the Republican side. There's a super PAC set up to support President Obama. There's going to be tons of money coming in there too. In my view, and I think this is the overwhelming view of American people, this is a horrible way to run our elections. Now, there are a lot of things we can do to sort of offset the impact of Citizens United, but at the end of the day, we've got to undo the decision. And the only way to undo the decision is for the court, because this was grounded in the First Amendment as a constitutional protection, the only way to undo the decision is either for the court to reverse itself, which is not going to happen with the current configuration, or to have a constitutional amendment that overturns it. And that's going to be a long haul, but I think we have to have that to restore our democracy. I think in 50 years' time, people are going to look back on the Citizens United decision the same way we look back now on the worst decisions in Supreme Court history, the Japanese internment decisions that upheld the right to return Japanese, the slaughterhouse cases holding that corporations couldn't be regulated. I think it's going to be viewed in that light. And I'm also certain that in that period of time, we will undo this decision.
Mr. Bopp, what about that?
Well, I think we found out for sure that Rob doesn't like corporations. And he thinks that because he doesn't like them and doesn't want to hear from them, that it's perfectly okay for the government to throw them all in jail if they dare to speak out. Well, you know, I don't like Harvard law grads. I think they're brainwashed. I don't think they like children as much as I do. I don't even think they like motherhood and apple pie and all the things that make life important and worth living. So then that means that I can shut up Harvard law grads, I guess. But, you know, it's a really I guess you just have to have there's just two ways of looking at this. You know, one way is we're going to have freedom. If you don't want to hear a speaker, then close your ears, use the clicker, walk out of the room. If you think they're speaking too loud or too much, well then get off your butt and go organize. And contribute to organizations that you think have the voice that you want to hear. Or we're going to start dividing it up and saying, who are the evil voices, and we're going to have the government shut them down. Now, there is bipartisan disdain for the First Amendment. A few years ago, when the 527s arose, and it looked like the Democrats were going to have an advantage with them, the Republicans wanted to ban them. Well, that was before I got on the RNC, and I got a resolution passed stopping that. But, you know, there were 2 years when they were out saying, well, we got to shut up these 527s. You know, and you know, the most sophisticated, probably, group of political thinkers and successful politicians that maybe the world has ever seen congregated in one place looked at that scenario and said, this is just not the way that we can make sure that people can participate. It's just a downward spiral. You know, he wants to shut up all the conservatives as best as I can figure it out. All right? Ken Mellman and his people wanted to shut up the 527s because he thought the Democrats would be advantaged. You know, this is just a downward spiral, and the only people that win out of that progression is politicians, and the losers are all of us, inevitably, all of us. Now, one thing I think we need to understand is the role of groups. George Soros has billions of dollars. He can spend that billions of dollars to affect an election. There's no law against it, and the reformers aren't proposing any law to stop them. What they want to attack is not the wealthy spending their own money. They want to attack groups. Now, it is true that rich people give money to groups, you know, but that's not a necessity. They can always spend their own money. They got the money. Big advantage, have the money. So what is the function of groups that is different? the role that it plays. Think of the Sierra Club, or National Right to Life, or Planned Parenthood, or What's Your Favorite Cause, and the group that supports that. What is the unique role they can play? The unique role they play is a vehicle for people of average means. People of average means don't have the money, so they don't have the money to spend. So what do they have to do? Pool resources. Your money and my money together in a group, now we can participate in an effective fashion. What they want to attack is groups. McCain-Feingold attacked advocacy groups, and political parties didn't lay a finger on the wealthy spending their own money. And there was not a single provision of that act that negatively affected any incumbent congressman in the United States. So what they were attacking is groups. And so when they talk about corporations or labor unions, that's what they're talking about. The only vehicle that people of average means can use to effectively participate, they want to shut them down, leaving it to the wealthy, the news media that are always exempted. By the way, they're corporations. I mean, ABC used to be owned by General Electric, a multi-billion-dollar international conglomerate of evil corporate raiders and people like that don't care about children, and the elderly. But they're always exempted, and that's what it would leave it to. So this is, groups play a critical role. Their effort to shut down through McCain-Feingold groups has the kind of effect on people of average means that I just don't think we should tolerate. I don't have a problem with the wealthy participating in elections. I just don't think they should be the only one that gets to participate in elections. People of average means have to have a role, and that's the role that groups play.
Can I change the discussion just a little bit? Because
Oh, come on, Val, you gotta let me respond to that.
sure, absolutely.
Because I want to.
The answer's no.
That's right. You cannot change it. Well, maybe I will.
I don't want to hear you.
Well, as you say, you're free to walk out. But so I wanted to agree with a couple of the comments and clarify some. Because some of the statements are untrue, at least as regards my position. I want to be clear about what that is, and I think there are some areas where we disagree. But we disagree. We agree what the terrain of debate is, and Mr. Bopp has a view, and I have a different view. The first thing is, a lot of the thing about Harvard Law School, that's true. I hope not all of us, Motherhood, I don't know. Most people seem to like their mothers there, I could tell. And I think it is also true that among the political parties there has been, there's often hypocrisy on this stuff. I think, just to give the example you give is correct, to give another example, which I think was very unfortunate. The Republican Party has historically been pro-disclosure, but the Republican Party opposed the disclosure bill that was moving through in response to Citizens United in 2010. That said, I want to say, as best I know, and I don't know everything you've done, I think your position is absolutely consistent. And I think our position, and to clarify what you're saying, our position is consistent. In the case of the 527s and so on, we're not apologists for the Democratic Party at all, and we've been very critical of corporate money that comes in either way. As well as, by the way, money from deep-pocketed individuals. It is categorically untrue that I or my colleagues, the best I know, certainly anybody who works in public citizen, are trying to shut down the voices of conservatives. It is true that we distinguish between corporations and regular people for the reasons that I was describing. And it's not a matter of whether or not corporations are evil. It's a matter of what corporations are and how they are different than real people. They have They are not people. People work at corporations, but corporations are a legal entity. And the issue here is not whether people who can work at corporations can spend money. It's not even whether they can group together as employees of the corporation and spend money collectively. It's whether the corporation can spend its own money. That's not money that belongs to the people who work for the corporation. It's the corporate entity's money. And the corporate entity differs from people in the ways that I was saying. And it's, I think, because of those differences, vital above all to stop corporate spending to influence election outcomes. Now, as it happens, I do have a problem with George Soros or the Koch brothers or other individuals spending millions or tens of millions of dollars to influence election outcomes. And I think we need campaign finance reforms that address that problem too. But it's related but a distinct problem from the corporate spending. And for me, the corporate spending, for the reasons I've articulated, is the most pressing thing to deal with. And just as a last thing, groups of people, for-profit corporations are not groups of people in the sense, in my view, in the sense that you're talking about. Citizens United, the organization, is a group of people. The Sierra Club is, the National Rifle Association is, and I believe that those organizations should be treated differently than for-profit corporations. The issue, as you know, in the case Citizens United wasn't about just Citizens United itself. It was because that Citizens United was an entity that was taking money from for-profit corporations. And if you don't acknowledge that you can subvert any restrictions on corporate spending, for-profit corporate spending could be completely subverted if they were allowed to just channel the money through nonprofits, you're not getting anywhere. So that's why the issue came up with Citizens United. But I agree there's a distinction between the interests of and the appropriate role in elections, but even more generally in democracy, between for-profit corporations and associations of people which may or may not take the nonprofit.
We're approaching the end of our time. Val, I say we have about 15 minutes or so.
Yes.
I thought, what if we switch to the disclosure issue? We've mentioned it, but we spent most of the time talking about contributions and expenditures of money. And one of the ways, potential ways of dealing with that problem, as you said, is to disclose who's giving the money. At least then you know who's responsible. I think that Jim has a different point of view on that it chills speech. To those who say that if I have to say that I'm contributing to the Vallis Nicias for a governor campaign, my friends won't like me. So I want to keep that a secret. That's a joke too. He's not running, and that wouldn't. But there are things you might want to keep the fact that you advocate a certain position or have helped a certain candidate a secret. This is it's an interesting thing. Does the First Amendment, freedom of speech, entitle you to be anonymous? Assuming we have a
position on disclosure?
I'm sorry.
What about, that's a very good question. I mean, is disclosure a good thing, bad thing?
Would disclosure cure some of the problems that Rob is alluded to, or would it create others?
Well, to answer the very last part, apparently no, because he criticizes groups that fully disclose, such as super PACs. So they're a federal political action committee that disclose, quarterly, monthly, every donor over $200, every expenditure over $200, and he condemns them. And of course, the reason is that it all goes back to spending. They just don't want people to be spending money on elections, and so the disclosure of super PACs doesn't solve the problem. I think, as to my view, I think disclosure is appropriate for political actors, candidates, political parties when they do election-related activity, PACs, and all of them are directly involved in elections. But as to others that are advocating issues, like you mentioned, the Supreme Court has recognized that there's a very important role for anonymity. As recently as 1997, where they struck down a requirement that Mrs. McIntyre put a disclaimer on the bottom of her piece of paper she was distributing, which opposed the school initiative. And that is because of a Supreme Court case in the late 1940s when the people of Alabama wanted the membership list of the NAACP, and they said, oh, they have all these good disclosure reasons. Well, of course, what they didn't like was the boycott in Birmingham, Alabama that was going on, led by the NAACP, and they wanted the membership list so they could target the people. And the court held that they could not have that, and that compelled disclosure to the public or the government of private information in private organizations will undermine them, undermine their effectiveness, discourage people from associating or participating with them, and it was a threat to the ability of people to come together and support controversial issues that they might want to advocate. So there's a dark side to disclosure. Nixon had an enemies list. Clinton administration, White House had 1,000 FBI files illegally. All these people, all these are efforts to identify, locate, and then punish your political opponent. The government does this. Politicians do that. Everybody knows it. That's the reason it's difficult to get people. Getting people involved in political activity is the most difficult thing. You know, it's a lot easier to get them to go to to help the local hospital. It's a lot more difficult to get them to support political activities because it's controversial. You create enemies, and the enemies may very well be governmental officials that decide whether or not you get a permit, decide whether or not they're going to paint they're going to fix your sidewalk. There's all sorts of things the government does, and if you get on the wrong side of them, you're fearful that you're going to be punished. So people don't want to do that. So there's a dark side to it, so it has to be very carefully used only in the most compelling and justifiable situations.
Bob, what about that?
Well, I agree with that. I agree with the principles you articulated. I think there's a difference in application, but I think it's exactly right to say there's a distinction between spending to influence elections and spending on issues in politics generally. And I think for the reasons you said correctly. I do think when you have issue organizations that are engaged in electoral activity, then their spending in that area needs to be disclosed, and there we might have a difference. But the broad principle, I think is right. I also think, although using a reason to denigrate it, I think disclosure is a positive. It does offer some benefits in the area of campaign spending. We're better off when we know where the big dollars are coming from than when we don't. We know that corporations are putting their money through entities that don't have to disclose because they don't want to be identified and they don't want their spending to become an issue in campaigns. I think that's a bad thing. However, and I think it should be stopped by more robust disclosure systems. However, it is absolutely the case that disclosure is a very mild palliative to what's a really, really serious problem caused by Citizens United. And if we had complete disclosure of all corporate spending that followed from Citizens United, it would only take us a pretty small way to addressing the problems that I've identified.
All right, gentlemen, we have about 8 minutes, 10 minutes left. Right. So with your permission, I'll open it up to the audience. And by the way, this is the first time ever in the history of the Louisiana State Bar Association, so I'm told, that we've actually invited laypersons to an LSTA function. Likewise, CNN was filming earlier. It's the first time we've invited the media in, free of charge anyway, to film. But we're blessed today because we have high school civics teachers, local civics teachers, and their students here in the audience. And it's our pleasure to welcome them. Likewise, any of you have questions for any of these fine folks, don't hesitate to raise your hand and we'll bring you a mic. So, questions?
If I may presume, quick question. Whose opinion is the corporations, if not the individuals running it? And if the individuals running the corporations are expressing the opinions that the freedom of expression grants, why can't the corporation give the money to the individuals and let them express it individually? Anybody?
Well, I guess you're asking that because of what he was saying about corporations. It's silly to think about a corporation, I think, other than as a collection of people with a common purpose, certainly. Some more narrow, some broader. Some we might share, some we might not. But they are certainly a collection of people that are engaged in a particular purpose. And collections of people get to speak just as much as us individually. I mean, if his position would prevail, it would mean the New York Times, because it's a corporation, would not enjoy the freedom of speech or of the press. That it would have to be, I guess, did Ben Franklin incorporate when he produced, his paper in Philadelphia? I don't know. I guess maybe he could run his printing press, but you're not going to have much of a circulation, and we just leave it to Ben Franklin and what he can do himself. These are just vehicles for people to associate together, gives them structure, gives them legality, gives them some protection from their personal assets being shanghaied for what the corporation does. That's what they are. Corporations are, and if association, the court has consistently held that association is a very important right that is encompassed within the First Amendment, because without it, we'd be just left with the George Soroses of the world and their multi-billions, and the rest of us would be just out to lunch. So.
John, question.
I just had a question before. You were saying that really the groups were the only way for individuals and ordinary people to participate, but it occurs to me that campaign contributions directly to candidates would be the way that they could do that. Is there a problem with just limiting that sort of speech?
Well, you mean that we would limit people's speech to only contributing to candidates? Is that what you're proposing? I'm sorry.
Essentially.
Okay. Well, the court has considered contributions to be, while speech, it's speech by proxy. In other words, it's you enabling the candidate to speak, and by giving them the resources to do it. And I cannot, obviously, it is true that in the history of the world, up until the United States Constitution, that people were prohibited from speaking about the government. And but that would just simply mean that we would not be engaged in self-government. We would not have elections of and by the people. Maybe they'd be, quote, for the people, that they can't participate in by talking to each other or speaking to each other collectively. But that's a radically different vision, I think.
And so, but the candidates themselves are a part of this government that is speaking.
Yeah, I'm not in favor of prohibiting candidates from speaking.
Okay,
I'm commenting on you wanting to prohibit individuals and citizens from speaking.
I'm just trying to understand. Your defense was about government, and then we're talking about candidacy. So
I don't know. I understand your question.
I just don't understand why the participation in electoral politics is identical with criticism of the government, since candidates are not the government. We lose candidates all the time around here.
Well, often candidates are governmental officials. Often that is exactly what we were talking about. Obama is up for election. He's a candidate. He is a governmental official. We're talking about his conduct in office. So really, you can't really often separate conceptually candidates and government because either are or certainly proposed to be a member of the government.
In case the differences weren't sharp enough, I just wanted to sharpen them a little bit. when Mr. Bopp talks about the ability of people to speak in the election process, it's worth remembering what Citizens United is actually about. And it's about the ability of corporations to take out television advertisements. And that's really that's the real issue. And I think that reframes it perfectly.
Any other questions?
Like this? Well, first of all, kudos to Val for putting this on. He's done it for several years, and we work together. And, you know, the sharing of ideas is what it's all about, whether you agree right or left, and for these students to see how the process is played through this year is really intriguing. And, you know, this year holds a lot because this is not only the presidency of Obama, but it's also the presidency of the President of France. And, you know, our economy, that presidency is in May, and ours is in November. And so the two are intertwined. You know, the economy in Europe is not much better than our economy. But if the issue is money, which is what I hear, corporations, whatever, what comes to pass to me are endorsements. And you got them today, you know, Rick Barry giving his endorsement to Greenwich. You know, what effect does that have, and who's going to contribute? Because now he's out of the race. George Bush, you know, supporting Governor Romney. The issue is, in which you don't see, I guess, is the bottom line is it takes a lot of money for a candidate. Our governor has a lot of money, and he's not trying for anything. It's just in his war chest. And as you had claimed, the $600,000 for the $10,000 seat for the city council is ridiculous. But unfortunately, that is a trend because it's a policy of influence. And whether it's the corporation that raises the money or it's the supporter that has a lot of money that spends it, the average individual that has access to anything, you know, it's hard for me to fathom that they would think that their $10, $20, $25 is going to make an impact on any election. And I don't think the news media has reported it very well, but that's what counts. And at the end of the day, I'm sure Bill Clinton's going to endorse somebody, and you go on and go on. And to me, that's the X factor. You know, what does the endorsement mean at the end of the day to the candidate that they think either will prevail or at least give them a good fight? And that's not really often reported. What's reported is, you know, this person gave a lot of money to this candidate. And so I say that, and I do think that this year holds some relevance to what we think as Americans should be and what we are and who we are. And at the end of the day, if the process, the electoral process is not validated, then we're going to have many more problems in the future. And for these kids here that will elect a president one day, I think they have to be cognizant of what we've all discussed today amongst, you know, all of you, which I thought was very good. And like I said, you don't have to agree, but the exchange of the ideas is important. I give Val credit for putting the panel on.
All right, we're about out of time. I'm going to leave you with one thought, which is, I guess, a moment of personal privilege. The reason, in my opinion, why this is so very important is because we're lazy, right? As voters, we're lazy. We don't do the investigation to find out about candidates. Instead, we flip on the TV and we see the advertising. And that's advertising is the money, right, to buy all of that time. And that's who we decide we're going to vote for. When we get to the vote, who ran the best ads, the most ads, who bought package, PR, candidate, whatever up there that probably has no relation with that individual was actually like. And maybe, just maybe, if we spend a little more time investigating those campaigns, wouldn't matter quite so much, right? We got involved in the process. If the great state of Louisiana decided in its wisdom that in order to graduate from high school in this state, you have to spend 1 credit hour of learning about civics in our government. That's it. That's all it requires. All right? Something to think about. I thank you all. Please join me in thanking me for